Good day, Crime Talk aficionados. We have a great show for you. First, there was a Bryan Kohberger hearing yesterday, and guess what? The judge is not buying what he is selling. We also had the Karen Reed verdict. Love it or hate it, you have to respect it. Mom-to-be was mowed down. I'm sure the defense will be there was no accident. The man learns his fate for protecting his property. We have this day in legal history. Legal quote of the day has to do with jury verdicts. The great selfie jailbreak involves our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us, and you know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. And yes, you can check us out anytime on any of your favorite podcasting apps. Now, before we get to the docket, let me remind you to go to crimetalksearch.com and sign up for that background subscription service. When you do, you'll be able to do as many background searches as you desire on anyone here in the United States. So whether it's one report or 1,000 reports or 1,001, it doesn't matter. Literally, while you do it, guess what? The report is emailed to you while you wait, and it's going to have all types of information about this person. It's going to provide you information as to their email address, their phone number, their social media presence. You're going to find out if they're married. Are they divorced? Do they own property? Do they have liens and judgments? Well, do they have a criminal history, and are they on a sex offender registry? Yes, everything you're going to be able to find out. So if somebody's coming into your life, or maybe you're thinking they need to get out of your life, go get some information. Check them out. Heck, your life could depend upon it. CrimeTalkSearch.com. All right, ladies and gentlemen, let me tell you a couple things before we get started on today's docket. Yesterday, I really wanted to be here because there was so much going on. Obviously, we had a show. It was before the Karen Reed verdict. It was also before the motions hearing as it related to Bryan Kohberger. And so I couldn't be there. And I had to go appear with a client in front of the grand jury. Not that, hypothetically speaking, if there were, 15 people to meet in a secret place, that's what it would be. So unfortunately, I had no access to my phone. I could do nothing yesterday. And I get out, and it was late in the afternoon, and I found out everything happened all in one particular day. So I wish I would have been there with you, been able to talk about it as well. Let's talk about it today. All right. So first on the docket, let's talk Kohberger. Faces a few setbacks as the trial judge signals, well, we're probably going to be in trial in August. So Bryan Kohberger, obviously accused of the brutal 2022 murders of 4 University of Idaho students, is likely to face trial as scheduled this summer, despite a last-minute attempt by his defense team to delay the proceedings. Now, in a critical hearing yesterday on June 18th at the Ada County Courthouse, Judge Stephen Hippler expressed skepticism about the defense's request to postpone the trial, stating it was likely to proceed on its current timeline. Now, if you watch the proceedings on Crime Talk like I did yesterday afternoon or yesterday evening, you could tell the judge wasn't buying what he was selling. He was just sitting up there. He was listening. He was being respectful. He was letting each side make their argument, but it's not going to fly. I think they're going to go to trial, but we'll talk about that more in a second. So anyway, for those who aren't familiar with the case, Kohberger is charged with the November 3rd, 2022 stabbing deaths of Kaylee Gonzalez, Madison Milgan, Xana Kernodle, and Ethan Chapin in their off-campus home. They're in Moscow, Idaho. Now, the case, marked by over 2 years of legal maneuvering and intense media scrutiny, has now reached a pivotal moment as the trial approaches. Now, the defense, led by Ann Taylor, argued that a recent Dateline episode and upcoming media projects include James Patterson's book, Idaho 4, An American Tragedy, and a Prime Video, One Night in Idaho, have prejudiced Kohberger's right to a fair trial. Now, Taylor cited the Dateline episode release with new details, such as the phone records and the surveillance footage, as evidence of a potential evidence leak, further complicating jury impartiality. She also noted that the defense is overwhelmed by 68 terabytes of discovery material, including evidence received as recently as this week, and they simply require more time to be prepared to tell Bryan Kohberger's life story for the penalty phase during the mitigation death penalty portion, sentencing portion, if he is ultimately convicted. Now, like I said, Judge Hippler signaled that the trial will likely proceed, advising both sides to prepare for the scheduled dates. I will tell you, it's likely you're going to trial on the date indicated. He said that he would take the matter under advisement and issue a written ruling. Now, when he does, we'll obviously bring it to you, and it's going to be one that we bring to you verbatim, line by line, sentence by sentence, paragraph by paragraph, because that will more than likely be, if Bryan Kohberger is convicted, one of the issues that they say is an appellate issue in the future. So just something to think about there when that comes out. Anyway, the prosecutors countered that delays would subject the trial to the whim of the media and that an impartial jury could be secured through the selection process. He also noted that Kohberger's team has had ample time to prepare since the arrest in December of 2022 of their client. Now, in a second closed-door hearing, the defense sought to introduce evidence of an alternate suspect or suspects based upon tips from the initial investigation. Now, while details remain sealed, well, it's been suggested that presenting such evidence could significantly impact the trial by offering jurors an alternate narrative to the prosecution's case, which relies heavily on the DNA evidence, the cell phone data, and surveillance footage allegedly linking Bryan Kohberger to the crime scene. For those who aren't familiar with the case, Kohberger is a former criminology PhD student there at the Pullman Washington University, and he was arrested after DNA on a knife sheath, just like this one that I've had since the summer of 1988. Didn't lose mine, Bryan. Didn't lose mine. Anyway, the DNA sheath found at the scene matched his profile. Now, Prosecutors also cite cell phone records showing his presence near the victim's home multiple times before the murders, and surveillance footage that the prosecution alleges is a white Hyundai Elantra matching Kohberger's vehicle, allegedly fleeing the scene. Now, a surviving roommate, Dylan Mortensen, reportedly saw a masked man with bushy eyebrows inside the home. And then we have the DoorDash driver who delivered food to Miss Kernodle shortly before the murders, claimed to have seen Kohberger outside the home that night. Both are expected to testify. Now, the motive for the killing remains unknown, and Kohberger has no known connection to any of the victims. But obviously, it's pretty serious because if he's convicted, he faces the death penalty, potentially by firing squad, which is a new law there in Idaho. Now, the Dateline episode revealed previously unseen and unreleased evidence and prompted Judge Hippler to investigate a possible violation of the court's gag order. Now, Kohberger's defense has requested a special prosecutor to probe the leak, though related filings are also under seal. Now, frustrated by the delays, the Gonzalez family expressed relief at the judge's indication that the trial will proceed, posting on their social media with the hashtag, quote, hashtag August 11th. Kohberger remains in custody as the trial nears, obviously, and he's entered a plea of not guilty, which means he is entitled to the presumption of innocence. Now, with the defense strategy unfolding and the prosecution evidence mounting, the case continues, obviously, to capture everyone's attention. This is going to be probably one of the more interesting cases in a while. Yes, there's DNA evidence on the inside button of the little sheath here. But the reality of it is that's powerful evidence, ladies and gentlemen. And you got the car and you maybe got the stuff. It's circumstantial, which means nothing. It doesn't mean that there's less evidence. It just means you don't have a direct witness telling you exactly what you saw on everything. But the jury is instructed that circumstantial evidence should be viewed as the same as direct evidence, right? Direct evidence, I look out the window, I see that it is snowing. I see that there is snow on the ground. I saw it. That is direct evidence. Circumstantial evidence, I go to bed. There's no snow on the ground. I wake up in the morning, I find snow on the ground, but it's not snowing. Circumstantial evidence would be, it snowed last night. Even though I didn't see it, I can reasonably deduce that there was snowstorm last night, right? Circumstantial evidence. Just like any piece of evidence, the jury can give any weight that they deem appropriate to that particular evidence. And the bottom line is they can either believe it, reject it, believe some of it, or none of it, or all of it. It just depends. Now, like I said, I hope this case gets going. 2.5 years is sufficient, in my humble opinion, as somebody that's handled lots of murder cases over the years and only done one. I told you I was on a case. It was going to go death, and we convinced him not to go death. So was it really a death penalty case? Well, it started out as one, and we convinced him to not go death. Even then, we weren't given forever. I was like going into court, Your Honor, this is a death penalty case. They're trying to kill my client. I need more time for mitigation. And the judge was like, yeah, sure, it's a 20-year-old cold case murder, but let's go. We're not going to delay this thing forever. And I see that's where the judge is going at. So although there's 64 terabytes or whatever amount of evidence there is, probably 1% of that is actually relevant. The judge knows that. The defense knows that. Now, am I bad-mouthing the defense? No, I'm not. The defense is doing their job. Okay? Sometimes when you got nothing, the best defense is delay. Ladies and gentlemen, delay, right? Because if nothing happens, like no trial, that means nothing bad can happen to your client. I tell you, like I said, done this for 30 years, ladies and gentlemen. We're giving you the inside baseball, the inside criminal defense gouge on what goes on and why we do it. Hopefully that's why you watch, okay? You can get a lot of echo chambers out there. We'll see. Listen, Bryan Kohberger, could he walk? Absolutely. Is there a pretty good chance that he may get convicted? Absolutely. Depends on how the evidence comes in, the jury, the prosecutors. It just depends. There's so many variables, which is a nice segue into the Karen Read acquittal in her high-profile murder trial. So as you probably know, if you follow anything related to the true crime world, yesterday, June 18th, Karen Read, the former adjunct college professor, was acquitted of second-degree murder, manslaughter, and leaving the scene of a crash resulting in death in the retrial concerning the death of her then boyfriend, Boston police officer John O'Keefe.
Defendant not guilty or guilty? So say you, Mr. Foreman? So say you all?
Now, the verdict, delivered after 4 days of jury deliberations that began back on June 13th, concluded a case that garnered obviously significant public attention through widespread social media coverage and an HBO documentary. Now, Read was guilty of operating under the influence, which is basically a DUI. For those who aren't familiar with the case, because there's lots of people who say, I have no idea what the Karen Read case is about. The incident occurred back in January 29th of 2022, when O'Keefe was found dead in this snow outside of a Canton, Massachusetts home owned by, at the time, retired police officer Bryan Albert and his wife, Nicole Albert. Prosecutors allege that Read, while intoxicated, struck O'Keefe with her SUV after an argument and left him to die in a blizzard conditions, and died and basically had head injuries and basically hypothermia. Anyway, the cause of death was determined to be blunt force trauma and hypothermia. Read maintained her innocence, asserting she was framed by O'Keefe's police officer friends, including the Alberts and their extended family, who were at the house where his body was discovered. Now, just remember, most of that evidence didn't come in because it was prohibited this time around. Anyway, Read and O'Keefe, who had been dating for 2 years, had been drinking at the Waterfall Bar and Grill in Canton before being invited to this after party at the Alberts home. Read testified, I shouldn't say testified. Her testimony came in as it relates to what she told the news media, that she had dropped O'Keefe off at an after party and returned to his home. She later awoke at 4 a.m., discovered O'Keefe had not returned, drove back to find him, ultimately locating his body outside of the Albert residence. First responders reported that Read, in a panic state, repeatedly stated that she had hit him. I hit him. Well, the retrial followed a mistrial from July of 2024, when jurors, after 5 days of deliberation on that go-around, could not reach a consensus on whether Read intentionally killed O'Keefe. And then in the 2025 trial, which spanned 31 days of testimony, the defense, led by attorney Alan Jackson, argued that O'Keefe was beaten and attacked by a dog inside the Alberts home before being left outside. They claimed that the investigation was compromised by State Trooper Michael Proctor, who was later discharged for sending derogatory text messages about Read, including calling her a whack job and joking about searching her phone for nude photos. Now, the defense asserted that the investigators targeted Read as a convenient outsider to avoid scrutinizing law enforcement officers, including Bryan Albert, his wife Nicole, their nephew Chris Albert, and Nicole's sister Jennifer McCabe, all of whom whom testified against Reed. But the prosecutor, Hank Brennan, the special prosecutor, I should say, he was brought in as a hired gun, countered that Reed, significantly over the legal alcohol limit, backed into O'Keefe with her vehicle while dropping him off at the after party and abandoned him. Now, the prosecution described the case as straightforward, rooted in Reed's intoxication and their tumultuous relationship. Upon hearing the not guilty verdict on the murder and related charges, Reed, dressed in her little light blue suit, visibly emotional, embraced her attorney like she has many times before outside of the courtroom. Anyway, outside of the Norfolk County Superior Court, she was met by a large crowd of supporters, many wearing pink, chanting, "Karen Reed is free." In a brief press conference, she expressed gratitude to her legal team and supporters, stating that no one has fought harder for justice for John O'Keefe than I have. Kind of reminds me of the time where O.J. Simpson said he was going to go search for the real killer on every golf course in Florida, where they can't enforce basically civil judgments against anybody. Anyway, supporters attended the court regularly, praised the verdict as a triumph of the American jury system, and the Commonwealth failed its people, a lot of the supporters said, and people obviously that were thinking that Karen Reed should have been convicted of something. Anyway, some people said it was a devastating miscarriage of justice. Other people say it was a miscarriage of justice. One, because Karen Reed was ever prosecuted, or two, that she was acquitted. You just have to pick your side. Who was outraged? Anyway, needless to say, there's lots of opinions on everything. So the case obviously has a lot of significant debate about the integrity of the investigation and the influence of the public perception. Now, Reed's defense highlighted alleged bias in law enforcement, particularly Proctor's misconduct, which fueled her supporters to believe that there was, in fact, a cover-up. The guilty verdict on the OUI charge acknowledges that Reed was impaired that night, though it doesn't address the broader allegation of this alleged conspiracy. While Reed has been acquitted of the criminal charges relating to O'Keefe's deaths, she still may face civil liability. A wrongful death lawsuit filed by O'Keefe's family against Reed has been on hold during the criminal proceedings, but is now likely to proceed, potentially becoming a focal point of the ongoing legal saga. And as the case concludes, obviously it remains a focal point for discussion on justice, media influence, and the complexities of high-profile criminal trials, ladies and gentlemen. The polarized reaction from the Reed supporters celebrating the verdict to the Alberts and McCabe's decrying it suggests that the public discourse surrounding O'Keefe's death will persist. Wow. Do I have a lot to think about this? I had a lot to say about this. First of all, first trial, I said I would have found her not guilty because I think the prosecution messed it up. Second trial, I think Brennan did an amazing job. He did. Frankly, he masterclass on cross-examination on many, many things. And as an attorney that does trial work, you may not like him, you may not like his style. He was good. He was very, very good. Okay. And he had to pick this mess up and try to fix it. And he tried to fix it the best that he could. Obviously, it didn't go far enough to satisfy the jury. Now, remember, should we be mad at the jury? No. Okay. Now, unless we were to find out that they were all Karen Reed supporters and they lied to get on the jury panel, then we would have something to argue about, so to speak. But I'm going to assume that they were answering questions in good faith when they were giving their responses in voir dire, and they simply were not convinced. And that's the way the system works, ladies and gentlemen. I've said this before. If you don't like a particular verdict and you think somebody got a not guilty when they should not have, don't blame the defense. They're doing their job, right? Trying to raise reasonable doubt, asking questions that maybe the prosecutor didn't. And so remember, it's not the defense that won. You really have to look at it as the prosecution failed. Okay. Now, I personally, a little surprised that they only got the operating under the influence charge. I thought the second degree murder was going to be a little tougher to get. But I also think, nobody explained why you backed up at 29 miles an hour on that road and then proceeded to drive off. There's also some privileged communications that were out there that most people will never get to see and hear between the defendant, Miss Reed, who's now been acquitted, and her attorney, and specifically as it relates to statements that she made. Now, those statements may or may not come out in the civil trial. They'll certainly have to be disclosed in the discovery process, and then they'll claim privilege to those communications, frankly, which they should be. Okay. But the reality of it is, here's two things. We say this all the time. Be humble, right? There's two types of people in the world, those that are humble and those that are about to be. Bottom line. Okay. You lost. The prosecution lost. It is what it is. You got to move on. I understand you didn't get justice for John O'Keefe. I get that. But I've said it many times before. If you're looking for justice, you're not going to find it in a courthouse. Okay. Somebody always goes away unhappy when it comes down to having a jury decide. Juries are a scary beast. You never know what they'll do. I have won trials that I should have lost. Lost a couple I thought I was in the game on, because you never know what that jury is going to do. Bottom line. On the defense side, if I was Karen Reed, I would be so humble. Okay. Whether you're factually innocent or there was enough doubt in the case, it doesn't really matter. I think I'd be humble. I don't think I would be out there giving interviews. I think I would move on and try to live a quiet life. And I'll be curious to see if people continue to support her in the defense of the civil case, which is a much lower burden of preponderance of the evidence, simply more likely than not. Kind of like OJ was acquitted of 2 murders, but he was found guilty by a civil jury by a much lower standard of proof. So we'll have to wait and see. Bottom line is, ladies and gentlemen, whether you like it or you don't like the Karen Reed verdict, guess what? You have to respect it. The jury has spoken. The prosecution had their best shot. It wasn't enough. The defense won. I hate to say it, I know, because people have died. It's kind of like a football game, a baseball game, a soccer match. It doesn't matter. At the end of the day, there's going to be a winner and there's going to be a loser. And someone's going to be bitter, but you got to move on. Okay. But remember, next time you get jury service and you think the system is broken, try to get on that jury. Don't lie, but be honest and try to get on that jury and make sure it works. The prosecution proves the case beyond a reasonable doubt. It is every juror's oath and obligation, solemn oath and obligation, to say guilty if they prove the case. And if the prosecution fails to prove the case to each and every element of the offense, it's the defense, it's the obligation, the solemn obligation of the juror members to find the defendant not guilty. You may not like it, but it's still better than anywhere else in the world. Next, let's talk about Gilgo Beach suspect Rex Heuermann and his Fry hearing, focusing on some DNA evidence. That's right. Yesterday, Rex Heuermann, the suspect in the Gilgo Beach serial killer, appeared at a Fry hearing at the Arthur M. Cromitty complex in Riverhead, Long Island, where his defense team challenged the admissibility of DNA evidence linking him to 6 of the 7 murders for which he is charged. Now, the architect, arrested back in July of 2023, has pled not guilty to the murders of 7 women, which include Melissa Bartholomew, Megan Waterman, Amber Costello, Maureen Brainerd Barnes, Jessica Taylor, Sandra Costilla, and Valerie Mack, whose remains were found on Long Island between 1993 and 2011. Now, during the hearing, Heuermann praised his defense attorneys, saying, "Good job," after questioning an expert witness by the name of Nathaniel Adams, a systems engineer from Forensic Bioinformatics Services, Inc. Adams testified about the unreliability of the IBD GEM software developed by Richard Green of Astera Forensic, used to analyze DNA from hairs found on the victims. Now, the defense argued that the whole genome sequencing techniques, novel in New York courts, lacks general acceptance in the scientific community. But guess what? The district attorney cross-examined Mr. Adams, questioning the limited documentation, 7 to 8 pages produced from 28 terabytes of data, and Adams' decision not to review the publicly available IBD GEM 2.0 software. Now, the lead defense attorney, Michael Brown, expressed confidence in Adams' testimony, noting that the prosecution's failure to validate the DNA testing process. Mr. Brown emphasized that Astera Forensics is not a certified lab and criticized Green's unfamiliarity with his own software. They underscored the unprecedented nature of this case, stating, "We are the first in New York State to address this." The prosecution, however, defended the technique as simply being reliable advancement in forensic science. Now, the judge will decide the evidence admissibility within the next hearing scheduled on July 17th, and Brown indicated that the trial is unlikely unlikely to begin before 2026. Prosecutors allege that Heuermann meticulously planned the killings, supported by evidence including hair linked to him and his family, cell phone data, and a planning document outlining his methods. The victims, who are all sex workers, were found along Ocean Parkway and other Long Island locations. Now, Heuermann's defense continues to seek separate trials for the 7 charges, arguing that a single trial risks jury prejudice. And there was a recent docu-series about this with the daughter, Victoria, stating that she believes that, most likely my dad committed the murders, while his ex-wife, Asa Elsrup, maintains that he is innocent. Now, this case began back in 2010 when there was the discovery of remains during a search for a missing sex worker by the name of Shannon Gilbert. Remains a focal point of public interest. Now, Heuermann remains in custody without bail, steadfastly asserting his innocence. Heuermann remains in custody without bail, steadfastly asserting his innocence as his legal team prepares for trial. That's going to be an interesting one, ladies and gentlemen. Obviously, there's always advances in DNA evidence, but you still have to be able to show that, although now DNA is widely accepted, if there's a new variance of it, you have to be careful. Do I ultimately think that it will come in as evidence? I'm saying yes. That's my prediction. Not even pulling out the magic 8 ball. Will the DNA in the Heuermann case come into evidence at trial? Magic 8 ball says, it's kind of floating around there, cannot predict now. Probably needs a little more information, like we would all love to have. Anyway, there you go. Big decisions, turn to the magic 8 ball. Next, a hit-and-run driver arrested in New York City for the murder of a pregnant woman. I propose a defense. There was never an accident. On June 18th, the New York City police arrested 28-year-old Chakwisa Pigford, charging her with second-degree murder and multiple other offenses in connection with a fatal hit-and-run incident that claimed the life of 32-year-old Tiffany Sifuni, a pregnant woman, back on May 24th in Brooklyn. Sifuni, a pregnant woman, in Brooklyn. Now, the tragic event occurred as Sifuni was returning home from a Beyonce concert at the MetLife Stadium. Now, according to the prosecutors, the incident began when Pigford, driving a stolen 2016 Chevy Trax, rear-ended Sifuni's 2021 Toyota 4Runner on Lewis Avenue. And after a minor collision, Sifuni followed Pigford for 2 blocks until Pigford stopped an intersection. When Sifuni approached Pigford's vehicle to exchange information, Pigford refused to engage. As Sifuni attempted to document the situation, Pigford allegedly accelerated, striking Sifuni and dragging her body under the vehicle. Sifuni was 12 weeks pregnant, became lodged beneath the car until Pigford drove over a manhole, dislodging the body. Pigford continued her flight, striking a parked Volkswagen SUV and a 2024 Grand Cherokee before abandoning the vehicle after blowing out both front tires. She fled on foot, later escaped to South Carolina, where she has relatives, before appearing back in Brooklyn. Now, Pigford faces a range of charges, including second-degree murder, manslaughter, reckless driving, driving without a license, leaving the scene of a deadly accident. And during the arraignment, the judge ordered that Pigford be held without bail. Approximately 10 of Sifuni's relatives, including her husband, James Sifuni, attended the proceedings, and James Sifuni described Pigford as a coward and a monster. Pigford's attorney argued for a $10,000 bail, citing her community ties and employment as a home health aide, but that request was denied. Ms. Pigford, who denied responsibility for the crash, is scheduled to appear in court on July 30th. Like I said, ladies and gentlemen, what accident? Do we even know how she died? I'm not even sure. I bet I could find some biomechanics people say it's completely impossible for that to have taken place that way. I don't know. Next, a former Space Force sergeant convicted in a fatal shooting of a teen in Colorado. So on July 5th of 2023 in Aurora, Colorado, an incident unfolded when Orest Shore, a then 29-year-old Space Force sergeant, shot 2 teenagers, resulting in the death of a 14-year-old by the name of Xavier Kirk. Now, Shore, who believed the teens were attempting to steal his wife's white Hyundai Elantra, was convicted on Monday of second-degree murder and attempted second-degree murder. Now, this incident began just before midnight when Schur was awakened by his car alarm, observing two teenagers dressed in all black near his vehicle. He suspected a theft was in progress. The teens fled in another vehicle, and Schur pursued them. After they crashed a few blocks away, Schur fired his weapon, fatally wounding Xavier Kirk and injuring a 13-year-old accomplice who later underwent surgery after fleeing to a relative's home. Now, Schur claimed the teens had drawn a gun on him, but investigators found no evidence of shots fired at him. His wife contacted 911, noting that this was the third reported theft attempt on their vehicle. She later told police that Schur was deeply shaken by the event. Now, following the trial, the jury opted to convict him of second-degree murder and attempted second-degree murder charges rather than the more severe first-degree murder. Schur will be sentenced on August 15th. Yeah, and guess what? That second-degree murder conviction for the kid that was trying to steal his car or did, mandatory minimum 16 to 48 years here in the great state of Colorado, while the attempted murder charge carries a mandatory minimum of 10 to 32 years that by statute have to be consecutive because they're separate victims. So at a minimum, he is looking at 28 to 80 years, if I did my math correct, ladies and gentlemen. Now, Schur, a former signal intelligence analyst at the Buckley Space Force Base, had a distinguished military record, including 2 tours in Afghanistan and 14 service awards from his prior Army service. He was discharged from the Space Force in the summer of 2024. Anyway, the victim's mother, Leslie Kirk, expressed profound grief, emphasizing that her son was only 14 years old and had his life ahead of him. She criticized Schur's decision to taking matters into his own hands rather than contacting law enforcement, saying, "My son was just a kid." And I'd say, ma'am, why was your 14-year-old son out in the middle of the night breaking into people's cars? That's always the question you get, right? And I've represented the shooters, I've represented the family members, but the question that begs is when the victim shows up and all the families show up in the courtroom, oh, my son, oh my God, he was the greatest thing. He was he was in line to be Pope, right? But why was he out in the middle of the night doing stupid stuff, putting himself in dangerous situations? Now, I'm not condoning, and obviously a jury basically was convinced beyond a reasonable doubt that Schur committed the crime. You got to respect that. And, those kids being out in the middle of the dark, middle of the night, is not a defense. And it's property. You can't shoot them. And you can say they had a gun on you, but you better be able to prove it that they did. And so I'm mixed. I'm mixed on this stuff, ladies and gentlemen. Obviously, as a criminal defense attorney, I would advise anybody, it's stuff. Let it go. It can be replaced. It'll be inconvenient for a while. But I also understand the victims like, no, that may be my only car. And if I don't have a car, I can't get my kids to daycare. And if I don't have my car, I can't get to work, which means I'm going to lose my job, which means I can't pay the rent, which means I could get evicted. So it's not just stealing stuff. It's the stuff that people need. I don't know. Tough decisions to make. Generally, as a basic rule, you can't kill people for stuff. And you have to be able to convince people that you were in fear of death or serious bodily injury by them taking your stuff. Pretty tough stance to do, particularly when these kids, in this particular case, fled. We just resolved the case, just like this. Very similar. Maybe you had a store owner that hypothetically shot at some kids that stole a bag of chips, hypothetically shot at the kids. No proof that the kids shot back or shot first. Man who never been in trouble before a day in his life, an immigrant turned legal citizen, business owner, was facing attempted murder, 16 to 48 years. I don't know. Got to be a better way. I got an idea. How about the parents not let your kids run amok? If when I was running around as a kid and I got in trouble, my parents would be like, "Oh, you got my permission to beat him if you think he's doing something incorrect." But we don't do that anymore. And I'm not promoting child abuse, ladies and gentlemen. I just think there's a lot of helicopter moms out there these days. That's all I'm saying. Next on the docket, June 19th of 1862, President Abraham Lincoln signed a law abolishing slavery in U.S. territories, a precursor to the Emancipation Proclamation, marking a significant legal step towards ending slavery. On this date, June 19th, 1865, General Gordon Granger issued General Order Number 3 in Galveston, effectively enforcing the Emancipation Proclamation and freeing 250,000 enslaved Texans, now commemorated as June 19th, 1866. The first official Juneteenth celebration took place, growing tradition and grassroots legal political advocacy. And then on June 19th, 1964, the United States Senate passed the Civil Rights Act of 1964, 73 to 27, a cornerstone law prohibiting discrimination. And do you know who the holdout was on that? Remember the filibuster? Al Gore's father. That's right. All the Democrats voted against it, or most of the Democrats voted against that during that time period. And then on June 19th, 1975, Sam Giancana, the former Chicago mob boss, was murdered in Oak Park, Illinois. Still remains unsolved. Next, our legal quote of the day. Since we were talking about jury verdicts, it's better that 10 guilty persons escape than one innocent suffer. Sir William Blackstone, Commentaries on the Laws of England, 1765. Now, this quote encapsulates the principle that a not guilty verdict prioritizes the protection of the innocent over the risk of allowing the guilty to go free, a cornerstone of our legal system. And finally, our dumb criminal of the day, the great selfie jailbreak. That's right, a tale of trespass and terrible decisions. Now, in a world where social media reigns supreme, one 19-year-old New Yorker, Cody Mallon, took the pursuit of the perfect selfie to a criminally absurd level. On June 16th of 2025, Mallon etched his name into the annals of stupid criminal history by breaking into a decommissioned correctional facility in a misguided quest for Instagram glory. If only his selfie stick had come with a side of common sense. Picture this. It's past midnight, the witching hour for bad decisions. Mallon, armed with nothing but youthful audacity and a smartphone, spots a hole in the perimeter fence of a former jail. Most people would see a rusty barrier and think, nope, that's a hard pass. But not our intrepid influencer in the making. To Mallon, that hole was a portal to viral fame. So he crawled through, likely imagining the caption, "Locked up and loving it. Jail vibes." Anyway, once inside, Mallon's plan unraveled faster than a cheap sweater. He wandered into a cell and in a twist that would make Kafka chuckle, somehow managed to trap himself inside the cell. Yes, this aspiring social media star locked himself in the jail cell. The irony is thicker than the bars he was stuck behind. Panicked, he did what any self-respecting Gen Zer would do. He called the police on himself. When the cops arrived, they must have been torn between laughter and disbelief. They freed Mallon from his self-imposed captivity, only to promptly arrest him for criminal trespassing. Talk about taking one lockup for another. When questioned, Mallon offered a defense that could only come from the mind of a 19-year-old. He was just there to take selfies, because nothing screams aesthetic like a grainy photo in a derelict prison at 1 a.m. This case raises lots of issues, like what filter do you use for a jail selfie? Cepha or the vintage convict vibe? Or perhaps Valencia to soften the felony vibes? And how many likes is a criminal record worth? Mallon's story is a cautionary tale for the TikTok generation. No clout is worth climbing through a creepy fence in the dead of night. In a way, Mallon's misadventure is a gift to society. He's shown us that some delinquents are so eager for attention, they'll literally lock themselves up. If only all criminals were this cooperative, we could slash the corrections budget and redirect the funds to, say, teaching teenagers the difference between a good idea and a viral disaster. All right, ladies and gentlemen, that's all we have for you today. Let's not go through any creepy portals into abandoned correctional facilities this evening. That's all we have for you. Thanks for watching. We'll see you next time. And remember, the Constitution matters.